explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. So I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it. What, do we have everybody from Pittsfield PD here? Does Pittsfield have anybody on the road? I mean, I'm just thinking, no.
Fire department's here.
Yeah, everybody's here. You guys take care. Thank you, Mr. Schiller.
Thank you.
Can you, Mr. Schiller, can you approach on a separate matter? Court does call the case of Finny versus Sedoni. The first thing, you guys are gonna have to switch sides. Get your appearances, please.
Good morning, Your Honor. This is Megan Dogwalla on behalf of the plaintiff, P84205. Mayor, can you state your name?
My name is Maria Finny.
Peter Sedoni.
All right. It's a date set some time ago for a non-jury trial. Are the parties ready to proceed?
Your Honor, may I approach the bench and go off the record briefly before I begin?
Buckle up, guys. Today we're diving into a real courtroom drama that unfolds like a scripted thriller. The judge opens with a firm tone, immediately addressing past settlement attempts and clarifying jurisdiction. A courtroom fills with tension even before arguments begin. Can feel the weight of unresolved conflict just hanging in the air. And boom, the case is called. Finny versus Sedoni. Attorneys step forward. Positions are taken. And from the get-go, you know this isn't going to be some routine bench trial. This one's about to go deep.
I have a procedural issue.
A procedural issue?
Yes, I can stay on the record.
That's fine.
Oh. May I
What?
approach?
No, well, then I've got to have them up here. I guess, what is it?
Okay, so there is a counterclaim, which is what this is for full trial. There was already an order of eviction entered. I'm intending to move for summary disposition under C8 and C10. I need the opportunity to brief that issue.
Well, why am I here on the date of trial with that?
Right. So the last motion that was filed, it was back in July. I appreciate that this is a long time coming. So please, Your Honor, I'm not appreciating that at the court's time. However, I'm recently retained, and there's about 1,000 pages worth of evidence. This has gone to mediation. There's conflicts in the facts, even in what was submitted during mediation, and there's significant evidence indicating issues of fraud upon the court and other issues regarding insurance fraud by the defendants. And it is my professional opinion that it does substantiate claims under MCR 2.116 C8 and C10.
Well, the motion should have been brought before today.
Okay.
I mean, I don't know what particular issues you're talking about in terms of somebody committing fraud upon the court. And I'm just going to say this, if they were going to say this about the other side, if you're going to make that accusation, counsel, you better bring it. And it better be that, because if it's not, then I'm going to be exceedingly angry, because I don't like people. I do not like people accusing others of things like that without substantial proof.
Absolutely. It is a substantial issue in this case. My client's rights have been significantly violated. It's
by whom?
By former tenants. This started out as a non-payment of rent case. As I mentioned, there was an eviction action, there was an order of eviction. As you're aware, we're here on the bench trial for the counterclaim. I don't take a claim of fraud upon the court lightly. There is significant evidence to present that. And I don't want to disparage my client's rights by not attempting to have this dismissed under C8 and C10.
Well, I get it, but there was an attorney in this before.
He's exceedingly difficult to get a hold of. That was part of why I asked to approach the bench, but
He's
I understand
been
there's
held
not.
up. He was in court here Monday, so I don't know
Okay.
why he's not that difficult to get a hold of.
Asterisk. All right, guys, things heat up real quick here. The attorney drops a bombshell, claims of insurance fraud, procedural violations, and even fraud upon the court. The judge doesn't flinch. Instead, she doubles down with a warning that stops everything cold. Bring the proof or face serious consequences. You can feel the courtroom's energy shift as the judge's voice sharpens. This isn't bluff territory anymore. The suspense crackles as we're no longer just talking legalities, we're talking accusations that, if true, could flip the entire case upside down. Asterisk.
Okay.
Coming in on the date of trial, asking for an adjournment of these proceedings is not going to happen.
Okay.
So you guys either can try to resolve this thing, or we're going to try it.
Okay. Fair enough. Then I would request a brief recess to please speak to the defense.
Okay, see if you guys can work it out. Court's going to stand in recess.
14A District Court back in session, the Honorable Judge Simpson.
You may be seated. Back on the record, court does call the case Finny versus Sedoni. All the parties are present, and how did the conversation go?
It wasn't entirely productive, Your Honor. So we have back from 2021, a consent order for conditional dismissal. There was an eviction order entered after that time against the defendants. As it relates to today's full bench trial, it is based on a counterclaim that was filed on February 12th, 2021. However, again, it's my position that the counterclaim needs to be dismissed. There's not actual cognizable claims under the counterclaim, so that it would be right for dismissal under MCR 2.116C.
Why are they not cognizable claims?
The claims are not cognizable as defendants are now pro per in this case. This was filed by their previous counsel. There is not a...
We're back, and the pressure just keeps climbing. The defense attempts to dismantle the counterclaim, arguing it's legally empty and shouldn't even be heard. But the judge isn't letting them off that easy. She hits back hard, challenging every vague argument and demanding specifics. The courtroom turns into a chessboard of legal technicalities and strategic missteps. You can tell the judge is losing patience. She's heard it all before, and she's done with delays. This is the moment where the case hits a critical point. It's time to try it or settle it. No more stalling. Asterisk after a recess meant to cool things down, emotions explode instead. One side accuses the other of intimidation outside the courtroom, claiming they were pressured.
A cognizable claim in regard to the condition of the property as against my client for relief.
Why is that not cognizable?
Can you repeat the question?
Why is that not cognizable claim?
It's not a cognizable claim, Your Honor, because there is a conditional dismissal entered as it relates to the original complaint where the defendants were being sued for the non-payment of rent, where the counterclaim asserts a generalized claim without any sort of reference to a breach of habitability or constructive eviction. The way that it's written in this counterclaim, it's more pertinent to the affirmative defense that's given the case history here and the fact that there was an eviction order entered, at this time, this can't be a cognizable claim before the court. Both
I
parties-
don't, that doesn't even make any sense. If somebody says I paid 1,000 or rent was $1,000 a month, I didn't pay the $1,000, and actually I was living in conditions that I think the landlord may owe me money because I paid them or something happened to the unit. The very fact that there was an agreement to vacate the premises doesn't negate their claim for money. As it wouldn't the landlord, if the landlord had a claim for money.
Absolutely, Your Honor. My point is more towards, to back up slightly. This has been in court for a long time. There's a lot on the record, especially for something that started out as a non-payment of rent case. The defendants are the relatives of the plaintiff.
I'm aware. I'm aware of a whole lot in this case.
There are facts in the counterclaim that are very generalized. There's not a factual section or actual claims after that. It's very generalized, but it does assert
to accept a lowball settlement. But the real twist? The judge reveals that something one of the parties said today directly contradicts their earlier statements. The air goes still. The attorney is caught completely off guard. You can see it on their face. This moment isn't just tense, it's a bomb about to go off. Trust inside the legal team starts to crack, and the courtroom dynamic shifts again. Asterisk. This is where everything nearly unravels. The
asserts that there's a dispute as to mortgage payments. There's a dispute as to ownership interest. So this is out of the realm of a landlord-tenant non-payment of rent case. And it's not a cognizable claim under the statutory law for those damages. Secondly,
You keep saying that. Give me some case law that says that.
Okay. Okay, I move on to a second point briefly and then return to that, Your Honor.
Go ahead.
Okay. Secondly, after the generalized facts in the complaint, then the defendants move on to enter under a claim of statutory conversion, common law conversion, excuse me. Well, okay.
Regarding the insurance line.
It's both. In paragraph 28, it's combined into common law conversion and conversion under MCL 600.2919A. Now, again, of course, Your Honor, we're considering what the language actually is in the counter complaint, but it's to my point that these claims are entirely convoluted. But they're asking for, as you would be entitled to under statutory conversion, 3 times the amount of actual damages plus costs and reasonable attorney's fees. If there's no summary proceedings to be had in terms of the possession of the property, and what's at issue here are ownership interests and statutory conversion claim that exceeds $25,000, it's in the beginning, as I was arguing to you, that this would be appropriate for dismissal under MCR 2.116C7. However, even if
jurisdictionally or under 7? Why under 7?
Right. This is what I'm stating, Your Honor. In the beginning, maybe it wasn't helpful to move on to a different issue, but in the beginning, it's that there aren't cognizable claims that apply any longer, given the procedural history. Not only that, but also just the way that it's been written out here in terms of the habitability. I did need a brief moment to consult my information, but in terms of the habitability, the actual counts that would indicate that the legal requirements have been met are not enumerated. And then secondly, it would be appropriate under MCR 4.002, not necessarily to dismiss the action, but if it's
Attorney, clearly shaken, moves to withdraw from the case entirely, saying they can't represent a client whose facts are falling apart under pressure. The judge doesn't argue. In fact, she practically confirms the damage, referencing prior statements that don't match what was said today. It's the most human moment in the whole proceeding, raw, honest, and painfully revealing. The court pauses once again, but this time the issue isn't legal, it's personal. A lawyer on the brink, and a case teetering toward collapse. Asterisk, and just when it seems
related to property ownership, which is quiet title, and if it's related to conversion for a claim of over $25,000, it's not the court's obligation to dismiss it, but it would be more proper that this be transferred to the circuit court.
And have you asked for removal?
I would request a removal, Your Honor.
I'm not removing this case.
Okay.
I think it was, and you coming late to the game, I think I explained to the Sedonis, I don't have jurisdiction over the title.
Okay.
I also explained to them that my jurisdictional limit was 25,000. I explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. So I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it. Anything else?
I mean, I have to object to proceeding on a full hearing at this time. For
On what grounds?
the numerous reasons I've stated.
You stated a lot of gobbledygook is the only way I can explain it. You haven't given me a reason. You haven't given me a reason why it shouldn't proceed today. This matter has been set for trial today. I have given a lot of leeway to both parties, I think, in terms of trying to make sure to try to resolve this case, to try to find a way to do it, sent them to mediation. They went through basically a mediation with me regarding this case on a couple of occasions. And it's come down to the date of trial. And now you come in wanting further delay. And I'm not delaying this.
It's not that at all, Your Honor. I just want to do right by my client. I was hoping I could approach the bench. I understand there's not another attorney and a party will also have to be able to. But I would like to go off the record for a moment if it's acceptable to you.
Do you have any objection to that, folks? No. All right. I don't know how we're going to have this conversation, but let's do it this way. We can go off the record. Mr. Trapp, take both parties, behave yourself when you're in my hallway, take them back to the jury deliberation room. When you're seated in the deliberation room, I don't want either one of you saying anything to anybody until I get there. We clear? Ma'am, am I clear, Ms. Finny? All right, take them back to my jury deliberation room. And the court will stand in recess. My understanding is the parties have had further discussions. Did anything come out of that, or are we still?
Yeah, talk.
Sure.
When we came back in.
seemed like everything was headed for trial disaster, the unexpected happens. Resolution. The parties return to announce a full settlement. Terms are laid out clearly. $10,000 in total, split between escrow release and monthly payments. The tone shifts from combat to closure. Each party confirms understanding. Even the judge, who's weathered the entire storm, acknowledges how long and difficult the road has been. It's a rare moment of calm after chaos. All right, guys, if you found this breakdown as compelling as the courtroom itself, make sure to like the video, subscribe to the channel, and we'll see you in the next one.